Assalamualaikum warahmatullahi wabarakatuh. So for today, our group will going to present about one case that included in law of contract, which is case Inche Noriah versus Sheikh Ali bin Omar. So for the table of content, we will discuss about the summary of the case, the judgment, statutory case, and finally refer case. So for the summary of the case, based on our reading for our first case, Encik Noriah vs Sheikh Ali bin Omar, we have summary for this case. An educated all Malay woman executed a deed of gift of a landed property in Singapore in favor of her nephew who had been managing her affairs. Before executing the deed, the donor had independent advice from a lawyer who acted in good faith. However, he was unaware that the gift constituted practically the void of her property and did not impress upon her that she could prudently and equally effectively have benefited the done by bestowing the property upon him by a will. The topic that related for the case of Encik Noriah vs Sheikh Ali bin Omar is consent. Provided by the law, consent occurs when the two parties mutually agree to form a contract with each other. Consent cannot be given under pressure. If one or both parties provided their consent under duress, the contract will not be legal. Both duress and undue influence can cause the contract to be voided. Section A, Section 1 state that all agreements are contract if they are made by the free consent of party competent to contract for a lawful consideration and with a lawful object, and are not hereby expressly declared to be void. The third element of contract deals with the consent or understanding of the parties regarding the proposed contract. Consent or assent of a party to an agreement must be genuine and voluntary. This assent will not be genuine or voluntary in certain case of mistake, deception, or undue pressure. This is where an existence of undue influence is depending on proof by party to a contract or by an assumption by court, or when the contract was obvious to be advantage only to a one party. When a contract has the potential to affect the general public, statutes can detect the contract's terms. Insurance contract, for example, can include terms that are restricted by statute so that the person carrying the insurance will have access to resources if they are hurt in accident. If there is no agreement between two parties, whether implied or expressed, no contract exists. Only valid contract can be enforced. The court is the only body that has the ability to enforce a contract between two parties. The court will only enforce agreement that already exists, meaning that they cannot create an agreement by imposing terms of party. Based on the judgment, based on the case, an uneducated old Malay woman executed a deed of a gift of a landed property in Singapore in favor of her nephew who had been managing her affairs. Before executing the deed, the donor had independent advice from a lawyer who acted in good faith. However, he was unaware that the gift constituted practically the worth of her property and did not impress upon her that she could prudently and equally effectively have benefited the done by bestowing the property upon him by a will. The court decided that the gift should be set aside with presumption of undue influence, which is raised by the leadership proven to have been in existence between the parties. Through the court, the judgment that decided by the judge is the contract made by the appellant is void. This is because the claim by appellant's right of the property is obeying section 16 that consent is said to be free when it's not caused by undue influence, which represent party mental capacity is temporarily or permanently affected by reason of age, illness, or mental or bodily stress that appoint the old woman, Encik Noriah, that defended. Section 16 states that a contract is said to be induced by undue influence where the relations subsisting between the parties are such that one of the parties is in a position to dominate the will of the other and use that position to obtain unfair advantage over the other. Inche Noriah is induced by her nephew Sheikh Ali because of her age and agree to give him all of her property. However, the nephew had not enough evidence to the elderly employs undue influence. So we are going to the end of the case. So that's all for case Inche Noriah versus Sheikh Ali bin Omar. Thank you for your listening, and now we are going to the next case. Thank you.
Bismillahirrahmanirrahim. Assalamualaikum. So now we are going to talk about Caltex Oil Malaya Limited versus Yoke.
Discharge by performance. In this case, it is under discharge by performance. A contract automatically comes to an end if it is discharged by performance. A contract can be discharged by performance, thus ending the agreement. When a party offers to perform, this offer is referred as a tender. If one party meets the other terms and obligation of the contract and the other party fails to do so, or if one party fails to accept it, then the contract can be discharged by performance. The parties to a contract must either perform or offer to perform their respective promises, unless the performance is dispensed with excuse under this Act or any other law.
Summary. The vendor, YFC and HHC, granted to the plaintiffs an option to purchase a parcel of land made up of lot numbers 145, 3 and 165 on March 26. Lot 3 was state land, which had been approved by the collector of land revenue to the vendors, while Lot 165 was acquired on October 12, 1961. Next, on September 22, 1961, the plaintiffs received the option and requested the vendors to deliver document of title and registrable transfers in exchange for 33,500 for deposit. The vendors called at the office of the plaintiff's solicitors but produced no document of title. The plaintiff took back their check but paid a similar sum to the solicitors to be paid out to the vendors when the ownership details were satisfactorily settled on October 12, 1961. On the same day, the vendors' solicitors wrote to the plaintiff's solicitor informing them that the vendors had purchased Lot 165 from the beneficial owner and requested the plaintiffs to pay 90% of the purchase price in advance. On October 21, 1961, the vendors applied to the collector for a variation of the express condition attached to the alienated portion of Lot 3. Upon the collector refusing this on April 7, 1962, the vendors' solicitors wrote to the plaintiff's solicitors conveying the information and concluded by requesting an advance payment. Since the tenancy agreement is void, the vendors' solicitors wrote to the plaintiff's solicitors that the vendors considered the agreement to be at the end on May 8, 1962. Under the doctrine of absolute obligations, the defendants will be liable to the claimants because under the agreement they would no longer be able to perform their obligations which had been contracted for.
Judgment. Inche of the High Court held that certain clauses in an option agreement to purchase a parcel of land were reciprocal promises intended to be simultaneously performed within the meaning of Section 52. And in the absence of express term to the contrary, it was a well-established practice that in the contract of sales and purchase of land, payment not a condition precedent to execution or transfer, the plaintiff will allow specific performance of the contract, and the defendant contention that the plaintiff had default in payment was rejected. Although the tenancy agreement was signed, In fact, the court found that non-payment of the agreed sum was entirely due to the default of the defendant being unable to perform their part of the contract, and the sum of the money was ready and available all the times for payment to the defendant upon their production of relevant document of title, which they failed to do so. In order how to dismiss area measured and identify, the defendant would have to know the time of the agreement with the plaintiff of the prospective contract and its term. This is the case where the doctrine of impossibility through destruction of subject matters was established in this case.